Facebook has been sued not only by the FTC, but by every state except for South Dakota, South Carolina, Alabama, and Georgia. I looked over the complaints, I looked into the allegations, and I think Facebook's days as a dominant player are numbered. On December 9th, 2020, the FTC and a coalition of nearly every state sued Facebook for violating the antitrust laws of the United States. I looked at the complaint and I researched the issues involved, and as much as I enjoy Facebook, we may well be seeing the beginning of the end of Facebook as we know it. Before we get into the specific allegations of the complaint, let's discuss why the powers that be are targeting Facebook, and the reason for that boils down to privacy. If you run a small business, you probably know that you can run ads on Facebook and target a very specific subset of Facebook users. Very, very, very specific. For example, if I want to promote this YouTube channel on Facebook, I can specifically target people in Dade County, Florida that have homes valued at over $250,000 and are interested in law. I can do that. How does Facebook know that someone lives in Dade County, Florida? First, people willingly provide personal information, and people willingly provide Facebook with location data. And for the most part, people agree to provide this information to Facebook and could, if they choose and are savvy enough, avoid providing this information to Facebook. Accordingly, most people really don't have a problem with this level of information collection by Facebook. The problem comes from the next level of information collection that Facebook uses. You see, even if a user configures his phone and the Facebook app and his Facebook account correctly so that none of the information we previously discussed is providing willingly, Facebook still gets it anyways. How do they get it? Facebook tracks nearly everything that you do on your phone. Facebook tracks nearly everything that you do on your computer. Facebook tracks every website that you visit, even when you are not running the application, as long as you downloaded the application, as long as you allowed Facebook to place a cookie on your computer. Facebook even tracks many online purchases, when you order food from certain restaurants, for example. From all this data, Facebook can determine that there is a high probability that you live in a certain place, like Dade County, Florida. And Facebook can figure out if you own your home or rent. And it can even figure out if your house is likely worth more or less than a certain amount. Facebook's algorithms are pretty impressive. They're also extremely invasive. It is difficult for even the most savvy users to hide from them. And ordinary users, like me, effectively surrender all semblance of privacy if we want to use the Facebook application on our phone. Now, it wasn't always this way. Facebook originally sold itself as a privacy-minded company. At one point, it promised to not track users' activities outside of Facebook. Then in 2014, after becoming the clearly dominant social network, it changed its privacy policy so that it could track users' activities outside of Facebook to deliver targeted ads. Here's an example of how low Facebook has sunk in the past. Somewhere along the line, Facebook purchased an Israeli virtual private network application called Onavo. In case you don't know, a virtual private network, or VPN, is an application that allows users to be more anonymous online. Privacy is literally in the name, virtual private network. Even though Onavo called itself a VPN, it tracked everything that its users did, and that is exactly why Facebook bought it. Facebook utilized Onavo's tracking information for a time, and while it did state it was tracking users in the privacy policy, let's be honest, no one reads the privacy policy. Even I don't read privacy policies. Facebook used this data to target its takeover of WhatsApp and was hoping to use it for others. Facebook's hopes were somewhat dashed once Apple figured out what was going on. Apple actually kicked Onavo out of the App Store and threatened to kick out Facebook's other applications. A few months after Apple kicked Onavo out, Facebook voluntarily withdrew the Onavo application from the Google Play Store. However, it is very clear that Facebook only backed off of Onavo once Facebook developed its own internal tracking capabilities, which are at least equal to the information it got from Onavo and stretches across almost all of Facebook's users. To recap, when Facebook faced real competition from other social networks, Facebook competed on privacy. As it became the dominant social network, it has continuously scaled back its privacy protections for users. At the present, Facebook tries to track literally everything about its users: where they go, who they interact with online and in person, what their interests are, where they spend their money. And they make all that information available to advertisers who use it to sell more or less everything under the sun to the 2.7 billion Facebook users worldwide. And the utter disregard for user privacy is really what is driving the lawsuit from the powers that be. The core allegations of the complaints are that Facebook has taken illegal actions to drive out competition. These allegations fall more or less into two categories. 1. Facebook acquired Instagram and WhatsApp not with the intention of creating a better product for consumers, but rather with the intention of stopping major competitors or potential competitors from taking market share. 2. Facebook has an API that it allows third-party applications to use to log in and access Facebook data. The claim is that Facebook used access to those APIs in a way that killed competition. There are some other minor allegations, but those are the two big ones. Under the Sherman Act, the plaintiffs, the FTC in the states, will have to prove the possession of monopoly power in the relevant market and the willful acquisition or maintenance of that power as distinguished from growth or development as a consequence of a superior product, business acumen, or historic accident. The Sherman Act has two types of violations: per se violations and violations of the rule of reason. A per se violation is a violation of one of the specific acts set forth in Section 1 of the Sherman Act. These are actual agreements, conspiracies, or trusts in restraint of trade. If one of these is proven, liability is established regardless of intent or motive. A violation of the rule of reason is a totality of the circumstances test. Effectively, the challenged acts are examined to determine if they promote or suppress competition in the relevant market. We've covered the facts and we've covered the applicable law. Now let's look at whether Facebook violated that law. In my opinion, the plaintiffs have a strong case. Not airtight, but very strong. And I expect that the plaintiffs, the states and the FTC, will prevail. To start, the government is not going to have to prove that Facebook has pricing power to establish that Facebook has monopoly power. Rather, in United States v. E.I. DuPont Nemours and Company, the Supreme Court stated the rule that monopoly power can be established by the power to control prices or exclude competition. I think it will be easy for the plaintiffs to establish that Facebook has the power to exclude competition due to its sheer size and the so-called network effects, meaning that once all of a person's friends are on a particular social network, they are not going to go and look for a similar social network. To prove this up, the plaintiffs can rely on statements like this one from an email from Mark Zuckerberg to Facebook CFO David Ebersman. There are network effects around social products and a finite number of different social mechanics to invent. Once someone wins at a specific mechanic, it's difficult for others to supplant them without doing something different. It's possible someone beats Instagram by building something that is better to the point that they get network migration. But this is harder as long as Instagram keeps running as a product. Integrating Instagram's functions into Facebook is also a factor, but in reality, we already know these companies' social dynamics and will integrate them over the next 12 to 24 months anyway. The integration plan involves building their mechanics into our products rather than directly integrating their products, if that makes sense. One way of looking at this is that what we're really buying is time. Even if some new competitors spring up, buying Instagram, Path, Foursquare, etc. now will give us a year or more to integrate their dynamics before anyone can get close to their scale again. Within that time, if we incorporate the social mechanics they were using, those new products won't get much traction since we'll already have their mechanics deployed at scale. More succinctly, Mr. Zuckerberg stated in a February 2012 email that once someone wins at a specific mechanic, it's difficult for others to supplant them without doing something different. These statements by Zuckerberg describes network effects about as well as can be done and give the plaintiffs evidence of bad motive and intent behind the purchases as well. On top of being able to prove the power to exclude competition, it is also likely that the government plaintiffs will be able to prove pricing power. Remember, Facebook sells advertisements and allows them to be targeted in a very specific way. Some might argue that you can target advertisements on Twitter at specific demographics as well. I'm certainly not an expert on that, although I understand that Facebook allows for a lot more targeted advertisements. However, it is clear as day that Facebook has a much larger audience. While Twitter has about 340 million users, Facebook has 2.7 billion users. It is 8 times the size of Twitter. Accordingly, for social advertisements, there is little doubt that Facebook is the 800-pound gorilla. And I have little doubt that the government will be able to establish that Facebook has pricing power. So the plaintiffs will be able to prove that Facebook is a monopoly one way or the other. Will they be able to prove that Facebook willfully acquired or maintained its monopoly? Again, based on the evidence recited in the complaint, I think the answer is yes. This is where the allegations about the purchase of Instagram and WhatsApp come in. First, the plaintiffs have compelling evidence that Facebook acquired Instagram for the purpose of preventing a competitor from gaining a foothold in the social networking space. Let's start with this statement from Mr. Zuckerberg that was made in response to a shareholder that complained that acquiring a nascent competitor like Instagram was a bad idea, as another would just pop up and take its place. It's a combination of 1, neutralizing a potential competitor, and 3, integrating acquired products into Facebook. The basic plan would be to buy these companies and leave their products running, while over time incorporating the social dynamics they've invented into our core products. One thing that may make neutralizing a potential competitor more reasonable here is that there are network effects around social products and a finite number of different social mechanics to invent. Once someone wins at a specific mechanic, it's difficult for others to supplant them without doing something different. It's possible someone beats Instagram by building something that is better to the point that they get network migration. But that is harder as long as Instagram keeps running as a product. Integrating acquired products into Facebook is also a factor, but in reality, we already know these companies' social dynamics and will integrate them over the next 12 to 24 months anyway. The integration plan involves building the mechanics into our products rather than directly integrating their products, if that makes sense. By a combination of 1 and 3, one way of looking at this is that what we're really buying is time. Even if some new competitor springs up, buying Instagram, Path, Foursquare, etc. now will give us a year or more to integrate their dynamics before anyone can get close to their scale again. Within that time, if we integrate the social mechanics they were using, those new products won't get much traction since we'll already have their mechanics deployed at scale. This statement, in and of itself, tends to prove that Facebook willfully attempted to maintain its monopoly with the acquisition of Instagram. Is there an equivalent statement for WhatsApp? No smoking gun straight from Zuck's mouth that I saw. However, there is this gem from a Facebook manager. Worth it. Their numbers are through the roof. Everyone uses them, especially abroad. Prevent's probably the only company which could have grown into the next Facebook purely on mobile. 10% of our market cap is worth that. In addition, outside investment analysts clearly recognize that the WhatsApp acquisition was a move that fended off a nascent competitor. We feel it is easy to see why WhatsApp was more than just a messaging threat. Much like how the acquisition of Instagram by Facebook was both an offensive and defensive move, we think this acquisition not only expands the company's total addressable market and capabilities, but also covers its flank from the fast-growing messaging companies. At first glance, one may assume that WhatsApp is merely a texting app. However, WhatsApp is much more, sharing 600 million photos, 100 million videos, 200 million voice messages, and 19 billion messages per day. Moreover, users can also share locations, places, and communicate one-to-one or one-to-many. Given this functionality by WhatsApp and the focus of Facebook on communication and linking the world's population, we think WhatsApp and Facebook were likely to more closely resemble each other over time, potentially creating noteworthy competition which can now be avoided. Accordingly, there is pretty strong evidence that Facebook made the WhatsApp acquisition to fend off another nascent competitor. How about Facebook pulling access to its APIs from various entities, specifically applications that compete with Facebook? At first blush, it might seem like Facebook should have the right to do business with whoever it wants to, and for the most part, that is correct. However, when you have monopoly power, the rules change. And Facebook, which appears to have recognized that it has monopoly power based on certain of its internal statements, nonetheless did not modify its policies on providing access to its APIs until 2018 or so. Between 2012 and 2018, Facebook restricted access to its APIs to any entity that competed with it by offering any of its core functionalities. And there are some great internal statements that show that Facebook fully intended to restrict access to its internal APIs to any potential competitors. You may not remember Circle. I know I didn't. Apparently, it attempted to be a local social network, kind of like what Nextdoor is now. Circle made use of Facebook's APIs to grow, at least initially. Someone at Facebook wrote the following about Circle. They are duplicating the graph and doing a rather excellent job of it. They are also very directly creating a competing social network on top of that graph. They then cut off API access to Circle and told Circle that it was because of spamming users. Circle attempted to rectify Facebook's spamming issues and asked to have access to the APIs reinstated. Facebook replied, "While I appreciate that Circle has done all the items below or agrees to do them, we ultimately still have the replicating core functionality piece which can't be fixed." Circle's daily new users dropped from 600,000 a day to 0, and eventually Circle disappeared. There is more evidence recited in the complaint. In any event, I think it is pretty clear that the government plaintiffs will have the evidence that they need to prove that Facebook willfully acted to maintain its monopoly. Based on the evidence that I went over, I think it is pretty likely that the government plaintiffs will win their case. The logical next question then is what will ultimately happen to Facebook? Will it have to spin out Instagram and WhatsApp? Will it have to provide API access to anyone who wants it? To be honest, this is more of a political question than a legal one. Given the strength of the case, I don't think there's any way that Facebook lets this matter reach trial. Rather, Facebook is going to negotiate with the new administration, the new FTC, as well as the states that took part, and reach a settlement. I think that Facebook is probably going to be forced to spin out Instagram, even with the steps that it is taking now to integrate Instagram with Facebook. However, the way that Facebook spins out Instagram and the restrictions on Instagram in the future are going to be very interesting. The new administration is going to be friendlier to Facebook than the Trump administration was. And it is possible that Facebook will be allowed to hobble Instagram substantially before spinning it out, which will mean that Instagram will never really be able to challenge Facebook. I'm not really sure how the Biden administration will deal with this issue. However, I suspect that Facebook will be able to negotiate some degree of limits on Instagram's capabilities, which will give Facebook time to replicate any capabilities within Facebook to the extent that they are not already there. The key point is, will Instagram be able to access Facebook APIs when spun out, and which APIs? I suspect that Instagram will be able to access the basic APIs, but with a lot of restrictions on the data that Facebook has. This will lead to a viable but likely small competitor in Instagram. WhatsApp is one of the largest messaging applications in the world. It has about 2 billion users. Discord, by comparison, has 250 million. However, development of WhatsApp has not been a priority for Facebook. Other messaging applications like Discord have been refined and certainly match or exceed WhatsApp's features. And WhatsApp's functionality has not been integrated into Facebook at all. Rather, Facebook still uses its own messenger application. So I think it is likely that WhatsApp will be spun out as well, and the question is whether it will be spun out as a potentially strong competitor or in a hobbled way. We will have to see how the Biden administration negotiates that, but I think some of the same observations that I made with regard to Instagram apply. The key for whether WhatsApp can grow into a viable competitor will depend on its access to Facebook's core data, and that will be a key point of contention for Facebook. There will be other consequences for sure. I suspect that Facebook is going to be required to provide at least some level of access to its APIs. There may be some modest improvements in user privacy, although I think that the moves that Apple is taking right now are much more significant on this front than anything that the government will be able to achieve. The most important consequence that Facebook is going to suffer is that Facebook is squarely on the government's radar now. Every policy change that Facebook makes is going to be scrutinized and subject to potential litigation. Every time that Facebook wants to acquire a company, it is going to be looked at very carefully. Pure and simple, Facebook's ability to operate freely is over. I don't like to make predictions like this, but I think the days of Facebook being the dominant company that they are now is coming to an end. It won't happen overnight, but in 10 years, I suspect that Facebook will not have anywhere near the power that it now has. That's all that I have for you on Facebook. I know that when I brought this up originally, I brought up both Facebook and Google. However, for whatever reason, I thought the antitrust cases against Facebook and Google were similar. They are not. And to be honest, I'm not sure that any of the cases against Google is at all strong. The strongest allegation seems to be that Google pays Apple a lot of money to make it the default search engine on Apple devices. Everyone says this is a lot like what Microsoft did, but that is just not the case. While Google has a big percentage of search traffic, there are a bunch of other viable competitors, so I did not include the cases against Google here. I suppose I may do a video on those cases in the future, although it seems less interesting than Facebook because it's just not as strong a case. If you learned anything or found this video entertaining, please leave a like. Heck, even if you hated it, leave a like anyway. And if you'd like to see more content like this in the future, please hit the subscribe button and turn on notifications. Take care of yourselves and your family as the pandemic hopefully draws to a close, and have a great day. Bye-bye.